and Industry, Chennai branch today. He is a mechanical engineer from RC Calicut, and he has IPR PG diploma from University of Madras. From August 2002 to December 2008, he was examiner of patents, Patent Office Chennai. From 2009 January to December 2016, he was assistant controller of patents and design. His responsibilities deals with referring patent application to examiners for formal and technical examination, scrutinization of the reports, making decisions on grant or refusal of the application. Also deals with handling pre-grant and post-grant opposition cases and other related matters as per Patent Act 1970 and Patent Rules 2003 and the relevant amendments related in 2016. Also, he deals with supervising substantive examination, technical as well as legal, done by the examiner, like patentability and other technical requirements of inventions, ascertaining sufficiency of description of inventions, conducting novel research, reviewing patent specifications to determine scope and validity. He is a member of Advisory Committee on IPR, Kerala State Council for Science and Technology and Environment. He worked as a member of Technical Committee for preparation of Manual of Patent Office and Practice and Procedures. He has pursued IPR from specialization program from University of South Africa, joined course by World Intellectual Property Organization and University of South Africa, pursued entrepreneurship and IP strategy course from IIT Kharagpur. He is versatile in 4 languages, Malayalam, Tamil, English, and Hindi. He also exposed to the German language as well. He is a man with international presence and deals with a scrutinizer for patentability and an advisor for young inventors. We are extremely happy to have such a eminent and experienced hand to share their views and perspectives with us, and this will help each and every one of us to serve engineering aspirants in a more better way. With great pride and honor, I invite Shri M. Ajith to take in charge of this session. Sir, please. Hello.
Hello. I am taking.
Sir.
Yes. Hello.
Sir.
Hello.
Yes, sir.
Am I audible?
Yes, you are audible.
Yes, screen you can able to see?
Yes, screen is visible, sir.
Okay.
Yes,
Thank you,
yes,
sir. So, good morning, everybody. So, I am M. Ajith, Deputy Controller of Patents and Designs, Patent Office, Chennai. So, okay, of course, I mean, the last entry only because my friend, actually, Safiq, actually supposed to take the presentation because of some reasons, actually, I am taking. So, then let's start with the introduction of IPR and patents and their importance for our economic development. So, നല്ല ആശയങ്ങൾ കരസ്ഥമാക്കാൻ ഒറ്റ വഴിയുള്ളൂ. ധാരാളം ആശയങ്ങൾ സ്വരുക്കൂട്ടിയ ശേഷം മോശം ആശയങ്ങളെ ഒഴിവാക്കുക. അത് ഡോക്ടർ ലീനസ് പൗളിംഗ് പറഞ്ഞാണ്. ദ വേ ടു ഗെറ്റ് good ideas is to get lot of ideas and throw the bad ones away. So ആശയങ്ങൾ അന്ധകരെ ഭയപ്പെട്ടാൽ ക്രിയാത്മകത വളരില്ല, അതുകൊണ്ട് അവരെ അവഗണിക്കുക. So this is the So actually, these are the intellectual property officers in India. So you can see this is PPVR, that is a plant variety protection. They are having office at Delhi, and SICLDR, that is semiconductor integrated circuits, and their office at Delhi. And we have a training institute at Rajiv Gandhi Institute of Intellectual Property Rights. They have the training academy at Nagpur, and the patent office which I belong. So we have the office at Calcutta, Delhi, Chennai, Mumbai, which Chennai office which I am representing, and there is a design office. Actually, their examination, everything is happening at Calcutta, but according to the jurisdiction, you can file any design applications, any of the patent office according to the jurisdiction. Yes, and the trademark registry, they are having 5 offices at Mumbai, Delhi, Calcutta, Chennai, and Ahmedabad. And the geographical indications, they are having office at Chennai, and the National Biodiversity Authority, they are having office at Chennai, and the Registrar of Copyrights, and that is the office at Delhi. So these are the offices which handling the intellectual property rights in India. And you see, the what is creativity? The creativity is thinking of new ideas. Am I audible? No.
Yes, 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 sir. Yes, yes.
Okay, okay. So what is creativity? The thinking of new ideas. And what is innovation? Innovation is making the idea to work. So intellectual property rights is the creation of the human mind. So because this is we cannot able to touch it, right? Because as a physical assets, because lot of assets, so the property, if you think, first of all, it will come actually the house or land, the car, everything, this property only. So, but intellectual property is also a property which is a creation of human mind. We cannot able to touch it, and it helps boost the economy. And intellectual property rights is the protection, of course. The intellectual property rights is the protection of the creation of the human mind. So, because we are doing lot of creations, so we are not interested to the people simply copying it, right? So there should be a protection. There should be a mechanism should be there to protect these intellectual property rights, which is the creation of human mind. So, example, we can say for inventions, you have to go for patents. Inventions, you have to go for patents, and the features of the shape, say designs, so external appearance of that particular product. Actually, you can go for designs, and visual symbols. So that one you can go for trademark. So these are the, because the intellectual property rights. So intellectual property rights actually, there are different forms. So the moment you are thinking about the inventions, you have to think about patents. And the moment actually the logo and the name, that one you have to think about trademarks. And the copyright, the film, books, everything, that is copyright. And designs, external appearance of the particular product, it will go for designs. And trade secrets, and the geographical indication. So one by one we can see that. So what are the different forms of intellectual property rights? So I believe that this a theme is for entrepreneurship, and either entrepreneurship, they will go for either initially a startup company or MSME, or later on they will go to a large company. So you may be thinking, who can create the property? You can see, because there is a creativity is going on. It can be a copyrighted subject matter, and this inventions, that is a patentable subject matter, and the design, that is a design matter. So these are the things which is there. So you may be thinking, why is IP is important to us? So that is very much, because generally we know. So why should we learn that particular thing? If you want to learn, means actually, wow, how it is important to us, how it will be grateful to us, how it will be useful to us. Generally, you will think, right? So new and exciting inventions, because new and exciting inventions you see, because why this technology is there. So how I can able to speak from Chennai and you can able to listen from the various parts of the country because of the exciting inventions done by somebody else, right? So we are enjoying it, and so we are also duty bound to invent something, right? So new and exciting inventions, and so once in so because of these exciting inventions, actually a lot of jobs are creating for you, and once jobs are creating means okay, your family members also will get job, and indirectly it is turns to a stronger economy of the country, and helps you find a favorite products in the user angle. If you see, because why favorite products are coming, because of the inventions, because of the designs. So once actually that is protected, then only actually it will enhance, it will induce the creativity. Now people will, okay, once actually if you are inventing something and next day somebody is copy, means whether you will get an motivation to invent something, no, because so oh, there should be a protection, right? And help others and artists to be rewarded for their work, help household items to be useful and look good. So this is the reasons why IP is important to us, especially for entrepreneurship. It is creating jobs, so and it will actually initially it may be a startup company. Later on, it will change to a larger company, and you are creating actually more job opportunities, and indirectly and directly, actually you are uh, giving. Contributing to the stronger economy of our country. See, now let's see actually first of all what is patent. So patents are granted for inventions. So patents, the moment patents are there, you have to think about invention. So if you have inventions, so you have to go for patents, right? So what right you will, what is the scope of right, and exclusive rights granted by the government. Actually, this is granted by central government. So exclusive granted by the government to the inventors for making, using, and selling the patented invention, and prevent others from doing so for a limited period of time. So once if you are applying for a patent and the patent is granted to you, nobody can make use or sell this particular patented invention without your knowledge, right? For how much? For the limited period. So if you are getting a patent, so that will be the, if you got an Indian patent, so that is what is the territory is there, you will get the protection all throughout the India. Okay. And for that one, what is there? You have to fully disclose the invention to the government of India. And in turn, government of India is giving the exclusive rights. So nobody can able to use or make or sell that particular product without your consent. So, and territory right, it is territory right. If you are getting Indian patent, that is valid within the territory of India, and the term of protection is 20 years from the date of filing, right?
Ajit
So,
sir, hello Ajit
yes,
sir.
yes,
Can we apply for patent? Means as a team, can we apply or a
yes,
single
yes.
individual?
No. Actually, as a team also you can apply. So any questions means you can able to ask like this. So I can then and there I can able to answer you. So the group also you can because no, actually there is no limitation for the applicants, not individual, right? Actually it can be maybe, I mean I have seen maximum 15 people applied for a one patent together as individuals. Clear the answer?
Oh, okay sir. Okay, fine.
As per law, there is no
Excuse me, sir.
limitation for the applicants.
Excuse me, sir. Ajit, sir.
Yes, yes.
Sir, we have filed one patent and it is under consideration now. It's already filed, but the examination is yet to, we have to appear it for the examination. And suppose if there is a delay in the examination, how long is it valid? That is the filing. How long
Uh,
is it valid? How many years?
no, valid actually that because it is valid from the date of filing to 20 years. So actually, the 20 years period is starting from the date of filing.
Okay.
Oh, that 20 years is constant because that is from the date of filing, 20 years. So that
Okay.
is
Even if it is granted or not, it is valid till 20 years.
no. After grant only it is valid. So once it is granted, you can take, suppose anybody is copying this one, you can take infringement action from the date of publication to date of grant.
Okay. What is the period for, I mean, once we have published, how long is it valid?
Now, once it is published, from published to that actually term is from the date of filing to 20 years.
Okay.
Right now, madam.
Okay.
Term is from the date of filing to 20 years. Because why I am telling publication, the people should will be aware only after you have filed the application, after date of publication only. That is brief.
Okay. Okay. Thank you.
So yes. Okay. So shall I proceed? Okay. Okay. Then yes. Yes. Okay. Then actually generally there is a doubt is there for everyone. So whether can I invent? Yes, you can invent, because anyone can invent and solve the technical problem in their field. And simplicity is not a bar for patenting, because so inventions ranges from safety pin to satellites. So anything it will cover under patents. Of course, in Indian Patent Act some restrictions are there, but actually that I am not going to it, because actually my purview for this one is what are the intellectual property rights. So now is there, you may be thinking, I have an invention, what to do next? So of course you can publish it or you can go for patent office. And actually nowadays, because you can see so publishing means publishing in newspaper, media, journals, magazines, websites, etc. And of course you will get publicity if you publish the invention is interesting. And if the patent application, if you file a patent application after publishing, what is the problem is there now, your novelty will be losing. Novelty means new. So novelty of the invention is lost to the publication. So my sincere request to all those who are participating, and you can tell you this one also. First you file a patent application, later on you publish it, including the patent pending. Right. Patent pending application number, immediately it will be given. So you can publish it saying that actually stating the patent application number. And what is the patenting? You can first file a patent application with the patent office. You can publish your invention after filing the patent application. The patent office will also publish your invention in our journal. Actually, we have a patent office journal. It will be published every Friday. And hence you will get both publicity and monetary reward through the patents. So generally we used to tell actually patent is an award for an inventor and reward for an investor, right? Patent is an award for an inventor and reward for an investor. So hence you will get both publicity and monetary reward to the patents. And why we are getting patent? So once if you get a patent, actually it is valid throughout the Indian patent, I am telling. So if you want to file, if your invention is very good, okay, you can file outside also, because there is a treaty, is there, patent cooperation treaty. Actually it is valid around 159 countries. So your invention is very much valid, you can file PCT also. So within 12 months you can file a PCT application, so you can enter into each national phase. Okay, that is depends upon your commercial interest of your application. And EC actually is inventor or assignee. And the one of sir was asking, inventors means there is no limitations and applicants also invention. But if the college is the applicant, actually you have to assign that invention to the college, and the college will be the applicant. So that is what assign is telling. And once if you are giving a document which satisfies 3 criteria, what are they? It is novelty, inventorship, and industry applicability. That full disclosure you are submitting to the government of India, and government of India, it is giving an exclusive right for you for 20 years. Nobody can use or manufacture or sell within the territory of India within in the period of 20 years, right? So again, I am telling, so patent is granted for a product or a process or both which constitute an invention. So you can apply for a product or a process. So it should be constitute an invention. So see, and the government is giving you right to use or sell or offer to sell or import patent product or process to anyone with the terms which you decide. And I told you it gives a right to exclude others from doing anything. It can be making, using, selling, offering to sell, importing. The term is 20 years and the patent right is territory right, I told. So any doubt? Any doubt?
No, sir. No, sir.
No, sir. No, sir.
So patent is why? Because it is facilitated development a new and improved product and process as the case may be. Because you see why? I will tell you, you may be handling some mobile phone, right? And some of the aged stars will be, you can see actually there earlier it was a phone were there, actually that is a land phone. Later on somebody may be knowing it as a pager has come. Later on actually this mobile phone has come. So the people don't want to take the camera as that, so camera is embedded in the mobile phone. So nowadays if you want to now children want to do the mathematics or any problems, they want to hear some music, so that is embedded. Now why actually phone is there, why separate system? So that actually the internet, that 3G, 4G, then 5G is going to come, that is embedded, and lot of facilities are coming. Actually it is giving new product and process, and so that is actually somebody else invention we are using, right? So of course we have a duty bound to do some inventions for the development of our country, right? So grants limited monopoly over the patent invention. So it is actually for the term you will get a limited monopoly. Limited monopoly means you have exclusive right for the period of 20 years and keep competitors from second sourcing of the product. So your competitor also manufacturing same thing. So now actually again I will come to for the startup. So if you see, actually you can see, because sometimes you might have seen in the newspapers and all, or some companies acquired, some startup companies acquired by some multinational company. Why? What is the reason? You can think. If some multinational company is acquiring one of the startup company from Cochin or Calicut or anywhere country, means so their technology is good. So actually that technology is good. Actually that multinational company maybe needed this particular technology which is developed by this, because this startup company might have applied for patent, and they might have got a patent. And generally there is a rule is there, more multinational company will simply copy that because there is a patent is there, some patents are there. So what is the reason? Either they can acquire these patents or they can acquire this entire company also, that depends. So that is what a patent can be a tool for doing a business. So if you are going for a entrepreneurship, actually this is one of the must. So your technology, you have to be prevent, you have to be there should be a barrier, because there is a technological barrier. So barrier, how we can keep? Because you see, actually if you are buying a property, say you are buying a property, so how much effort we will take to safeguard that property? Because we will construct walls, we will put something, so many things, and we will put that camera, everything. No, so whether same effort we are doing for the intellectual property wise, because this is our own brainchild, so whether we are doing that much exercise to protect that one. So again, I am telling what invention is. Invention means a new product or process involving inventive step and capable of an industrial application. So what is an invention? Invention is nothing more than a solution for a technical problem. So if you have solved a problem, you have made an invention. So if you have solved a problem, you have made an invention. Okay. And of course, at patent office, in the primary constraints, it has to pass through 3 doors. It should be novel. It should not be non-obvious. Non-obvious, it should have an inventive step, and it should have usefulness. So this is one thing again and again I am telling, because generally, because we want the name. So in order to get the name, what is there, actually we will publish it. So later on, if after publishing, if it is coming to patent office, actually what they will do, sometimes they will cite that particular document and they will tell novelty is lost. So once novelty is lost, you may not get the patent. So that is the problem. So first of all, my request is that if you have a great invention, so you file it. And suppose actually another thing is there, if suppose actually patent office also missed, so if that particular product is very successful, then your competitor may also dig something, and they can also come to patent office later on by pre-grant or post-grant opposition. So in order to prevent that, if you have a good invention, so you file one patent application, later on you publish it. So invention must not be published in India or elsewhere. So worldwide this one, or in prior public knowledge or prior public use within India, or claimed before any specification in India. And you know, because sometimes, because in Kerala, if you see, the moment actually, if you see patent, means they will ask, oh, turmeric patent, you people has given turmeric patent, that is correct only. Not in India, that is actually granted by USPTO, that is United States Patent Office granted this one, related to wound healing property of turmeric. It is commonly in India, which is because everybody knows grant of patent is outraged by Indians. So of course, USPTO, they granted this turmeric patent. After that, there is okay, this is already commonly available in India. How they can able to grant that one? That's the people actually furious. So this patent was challenged by the way of re-examination at US Patent Office, and USPTO revoked that patent. So finally, that particular patent is revoked. And you should know because in order to revoke that particular patent, so we should produce some document. And you know, everybody knows that wound healing properties of turmeric. What is the document? We should have in order to revoke, actually, there should be a documentary evidence, right? So this is the documentary evidence submitted by the Government of India. This is the prior art available in the Urdu. And you know, because there is a translation is there, it is available in 1879. You can take taken directly as a blood purifier. This cures jaundice. So this is a proof the government has submitted, and after that only US Patent Office has revoked that. So now that particular patent is not available. And similarly, you know, basmati, because generally, actually, we Keralites actually like biryani, and biryani generally we use basmati rice. And that for that basmati rice also, there is a Rice Tech US Corporation, that company, they got patent. You know that basmati rice is grown in the somewhere in the parts of Punjab, that area, and to Pakistan, that area only. But Rice Tech one company, they got a patent for that one. So with the successful prevention, actually, instead of 20 claims, they are reduced to 5 claims. So again, there was a topic is their neem, you know, because neem trees. Neem, you may be aware that actually that is a fungicidal properties of the neem, and the neem is available largely in the Tamil Nadu and some part of the Kerala also, some houses it is there. So that was granted by European Patent Office because the fungicidal properties of the neem. But of course, you know, because there is evidence was there. Later on, the government of India with this one, they could able to produce that one, and finally that is got revoked. So this is actually aspects of traditional knowledge. So that is traditional knowledge. In order to avoid these type of things, actually government of India with some government agencies, they form a TKDL, traditional knowledge digital database, and it is circulated to almost all patent office, and this type of inventions has been prevented. And then this is what I am telling about novelty, and the next step of getting a patent is inventive step. So a feature of the invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, make the invention not obvious to a person skill that. Actually, that is what just novelty alone sufficient. Actually, it is having some technical advancements over the existing prior art, then only it will be eligible for getting a patent. This is the second door. And third is industrial applicability. Invention is capable of making or used in any kind of industry. So it can be made or used in an industry. So these are the main criteria, whatever novelty, inventive step, and industrial applicability. These are the 3 criteria for getting a patent, not only in India, all throughout the world. So these 3 criteria, wherever patent office you go, they will check these 3 criteria. After that only, of course, in India also, some other countries, there are some checks is there, section 3 and section 4. That much depth I am not going to it. Because now this explanation tools, you can see I told limited period of time, 20 years from the date of the application. That is the time. Madam was asking, what is the period of this one? 20 years from the date of application. That is the one. And after expiry, you may ask, after expiry, what will happen? The patent will comes to the public domain. And condition is there. Actually, you have to fully disclose your invention by the applicant, and must teach others how to make and use the invention, and must disclose the best way of making using the invention. So you may be having who is granting it. This one actually this is central government is asking, not central government is granting this one, not a state government. So that is national patent. So you may ask whether international patent is available. No, there is no international patent. International patent, actually patent is a territorial right. Of course, regional patents are there. So if you want to file an international this one, so there is a procedure is there, international application procedure through PCT, Patent Cooperation Treaty. They are having headquarters at Geneva. So there is a provision with a single application. You can file that application around 159 countries, but within 31 months, you have to enter into each country, right? So this is what explanation. So Indian practice is there first to file. You have to first to file an application, then only you will get. Because you can search also. There is a controversy is there. Alexander Graham Bell with Eliza Gray. Because we knows actually Alexander Graham Bell who had invented telephone, but Eliza Gray also meanwhile he also did the research, but who had first file applicant name only we know. And this is the story actually. Eliza Gray entered the famous legal battle, but famous actually finally we know actually Alexander Graham Bell only won. And you may be asking another doubts. So so invention can take place. What are the field invention can take place? No, invention can take place in any field. It can be electronics, it can be communication, it can be biotechnology, it can be nanotechnology, it can be Ayurveda and Siddha. So invention can occur, safety pin to satellite, anything. That is one. So any field can be done. The second myth is there. Actually, only multinational companies can apply patent. No, actually anyone. So those who are invented, if you have a solution for a technical problem, then actually you are eligible for a patent, right?
Ajith sir,
Yes.
one doubt. Suppose a person having one patent on a product and another person want to upgrade that product. Is there any issue?
No issue. Actually, if that because all are not blockbuster invention, right, sir? Actually, because that is improvement only will be covered under patent. So a patent office will check. Actually, you had done a product, and if another person want to improve, say example, substantial improvement means actually that's he is also qualifying for a patent, right? Because that is what you can able to see the patent studies. So each patent they are having some drawbacks will be there, and if another person actually covering some invention which is covering that drawback, that is an invention, he can file patent application, right? He can do it.
Yes.
Clear?
Yes.
Okay, fine. So you can see actually CEO short innovation distinguished between a leader and a follower. So MES, actually I also once I came for a seminar there. That is some long back, I think. So so you can see because that even actually nowadays if you see colleges, universities, everything actually rated based on the patent filed. And now actually earlier if you see how many paper published, now actually it is slowly changing how many patents applied by the institutes. And now later on actually it will change, of course, that will come how many patents are commercially successful, like that it will come slowly, it will come. But now at the present stage generally agencies will ask, so rating agencies will ask how many patent applications has been filed by the particular institute. So this is, of course, there is a as you rightly know, because every faculty member will be aware that this one, because if my this one is correct, actually now they are made with it to one patent application is equal to 2 paper publication, I think. So innovation distinguishes between a leader and a follower. And of course, actually now you can see actually recently our minister has already announced, because it has to come into rule. So the government they are planning to make actually all technical institutes, all academic institutes have equal fees like individual, because because individuals they are having 20% fees only, but the larger entity companies and all actually that is 100% fees. actually now there is a proposal is there, not implemented so far, but it will come so soon. So that they want to reduce the fees for educational institutions to 20%, equivalent to individual, to enhance the because there is, because generally in India, because our market size is very wide. So majority of the patent application filed by the multinational company, only 75% from multinational companies and 25% from only from domestic applicants. So actually, in order to enhance, actually so many policies is now presently adopted by the department. And innovation is any change, big or small, that makes a difference, Thomas Smith told. And you can see, because this is you may be thinking actually this what is this invention, because because that generally they were using the pin for the invention. Now jump clip is there, without mutilating actually can be hold. So that is invention. And as Sar was telling, because there is lot of modifications in the clip itself, and these are all patented also. So depends upon how effectively it used. So that way you can apply for different patents also. And this is one of the thing, because IP creation, IP protection, IP licensing, actually that is what the R&D Institute. And next slide I will tell, because I will tell R&D, because that is if MES Engineering College, that is a research organization. So day by day, actually lot of technology is coming out from that, whether it is protected or not different, but different lot of technology from the faculty members and students, it is coming. And you see actually a lot of industries will be there around the MES college. And if this technology is transferred to these industries, what will happen? It will be and new products will come, and society will get new products. Of course, gains will be there. And once gains is there, the profits received, industries will grow, and the research organizations, they will get royalty. So this is a model, because this is a relation with IPRs and industry linkage and the society. If this technology is hand over to the industries and new products will come, society will develop, industries will develop, and of course, and R&D actually, in addition to the academic, actually that is a research, they can use actually for development of additional funds from their technology, which is generated from your own college. So you can think, because you can see, because earlier speaker Preeti madam, actually she is from TBI, I think. So they are also using this one. And you can see Kochi University, Amal Jyoti Engineering College. So many people, they are having similar linkage, I think. So now actually patent I am covered. And if any patent doubt is there, you can ask now. I am ready to clarify. Okay. Hello. Hello.
Hello, sir. Hello, sir. Some in news dailies there was some controversies between Apple and Samsung, and sometimes Apple win the case, and sometimes Samsung win the case. Sir, why it so?
That will happen, because that is actually based on the feature they are putting. See, actually, this is cross licensing. Either they have to take a cross licensing, because actually both companies, they are working in the same field only. So actually both this one, in order to enhance a feature, both will be claiming different patent applications they will be filing. So depends upon the claims, they will sue each other. And according to the claims factor, both can win. And myself, I have handled so many cases with the TVS Bajaj, because both are in motorcycle, Indian companies, I am telling. Myself handled a lot of pre-canned opposition from TVS Bajaj, Hindustan Liver with Eureka Forbes. So a lot of application will come. That is definite. Because competitors, of course, they will sue each other and they will come. That is normal only. Because that depends upon the claim. Because because that is claim, what a feature they had invented. That
Yes,
depends.
yes, sir. But Apple wins in America, but Apple loses in Japan or Korea. The same case.
Yeah, that is what. That depends upon the judge, you see, Sometimes,
Yes,
yeah,
sir.
because sometimes you see in Kerala divisional single bench will tell one decision and divisional bench will tell different decision, same court only.
Yes, yes, yes.
So that depends upon the judges and how their arguments presented over before them. That is way only.
Yes, sir, clear.
Yes. Okay. So I am going for trademark. The trademark is rather easy. So this is also one of the major rule for the industry because rather getting protection is very easy and registration is easy. And trademark have been used to simplify the identification by consumers of goods or services as well as quality and value. So because a trademark may be considered as a tool of communication used by producers to attract consumers. So once I will show, you will be easily understand what is the trademark is, and it is plenty. It is renewable for 10 years. 10 years it can be renewable to any time, and registration is optional. But of course, actually, government and generally it is optional only. But this one is better to register it so that nobody able to copy that particular name, because names are very much important. You see, and because. Trademark is a sign or combination. It is help distinguish goods and service offered, and it should be distinct and it should not be deceptive. So you can see because Coca-Cola, Pepsi, Apple, these are the trademark, and you see actually there are slogans are there, a dil mange more, like that, and letters like IBM, LG, that and all trademark. And you can see the numerals like 43445, and sometimes signatures, sometimes pictures like these and all will come under trademark. And sometimes you can see the designs like this and symbols like this, it will come. So the moment if you see these symbols, we know that the particular product is coming from that particular company, and there is a some actually from this particular company that product is coming. Okay, it is having a value, it is worth. So depends upon the trademark we're valuing the companies, right? And you can be suppose the shape of goods or packaging or any combinations mentioned this one, and these are all coming under trademark. And sometimes a color, a combination of the above color, like that also will come under trademark. And you can see because there are some case laws are there, you can see that Lakme, because plenty for selling cosmetics under the registered term Lakme, and the defended use Lakme for the same class of product, and court held there is a striking resemblance, two words phonetically similar, so like that. So same class of goods. So injection was ordered and made permanent. So the second case law, we can able to see this trademark. A party made application for registering FISA code, and opponent were registered a proprietary trademark of a vehicle, argued on grounds, and application was refused. So trademark registry, based on this one, they will refuse, and if trademark office is not there, and they can go for high court also. So infringement suit, it can be revoked also. And some of the trademark you can see because these are the famous KFC, OD, Walmart, Apple. So the moment if you see this, we know that the particular product which is coming from that particular company, right? And you can see because the device, brand, signature, label, name, words, Google, letter, slogans just to do it, the combination of letter and design, logo. So the moment if you start a company, actually there should be a trademark. That one you can register that particular trademark with the trademark office. And sometimes shape of goods, smell, packaging, colors, these and all will come under trademark. So now this may be old. You may be thinking this man is showing the old one. Okay, because of course you can see because the moment if you know that is a paste only, but it is having different trademark. This is Colgate, Pepsodent, Close Up, and depends upon your taste you will choose which. Because nowadays, if you go into a shop and if you are asking for a paste, what will they will give? The shop owner will give what sometimes it is not saleable or some product will give. No, but in daily life, actually, we know this product we want, right? So how we are spelling it, that is the trademark which we are using, right? So, and if you, that company also, again, I will come. So if you are giving a trademark, it must be distinctive and should not be deceptive. So you can see, lion is a distinctive trademark for days, because day syrup and lion, there is no this one. So, and Annapurna, a distinctive trademark for wheat powder, and the cycle for agarbatti, apple for computers. So that is distinctive. No relation with the goods associated with it. And generally, what trademark office, they will not grant this type of they will not register this type of trademark, true basmati, real cotton, best camera, like that. So it should not be deceptive like that. They should not give the certain qualities which associate with that. And you say, because these type of things are is available, because Panasonic and Panasonic, and you can see these type of issues are there, because the people simply copy, and they are actually, what is the problem? As a customer, actually we are getting cheated. As a company, actually their profit loss is there, their revenue is reduced because of this. And you can see Adidas, Adidas, because because there is inferior products are available. You see actually this type of Puma, MV, that shoes, you see McDonald's, this one is there. So as a customer, we are getting cheated. So that is this one is Fiji bear, you can see, because this one. And this is Subina is there, you can see, because this is, so this is commonly we are using. So these type of inferior products are available. So actually, in general, two types are there. People are getting, actually customer are getting cheated, and there is a revenue loss for the company asset. So in that case, generally, if you are going for industry, trademark is a must. The name has to be protected through trademark. And now we have covered two, patent and trademark. And now industrial design. Industrial design is there actually. This is actually, you should not confuse with the patent and design. Actually, patent is taking about the functional aspects, and design is aesthetic appearance. So after looking that particular product, actually we should get affiliated. Okay, we want to buy that particular external appearance of that particular product. You can go for industrial design. Any new or original idea applied to an article whose pattern, shape, or configurations make an appeal to the eye forms an industrial design. So protection of industrial design is governed by Designs Act of 2000. Say, I will tell a sample, because Thrissur, a lot of jewelries are there. And if you ask your wife or your daughter or somewhere you go, this one, oh, they will tell, okay, this particular jewelry we can go, because you will get a particular design. There is attractive design is available in the particular jewelry only. So you see, so these actually because what is there after seeing that particular, because jewelry same, both are gold, everything gold only, but the design is different. So after putting that particular jewelry, and people will get attracted. So that is a creativity of somebody else. So that creativity, how it is protected, that is protected under industrial design. Okay. And why design registration is required? You may be asking to get an exclusive rate for the 15 years, 10 plus 5, and to obtain fair return on investment by getting bona fide reward for commercially exploiting, to promote fair competition and honest trade practice, and to preventing imitation of innovative design. Because this is the main thing, by preventing imitation of innovative design. And whatever this one is there, if that particular design is successful, people will simply copy it. So we have to prevent it. So for that one, and what is the remedy is there? That is design. So by preventing commercial exploitation of the innovative design by the third party without property's consent. So you have to have a unique selling point for the product in tough market competition. Actually there are a lot of products are there. In that one, before our eye will look for very different design, right? Generally, because that is human nature only. So if so many cars are there, our eye will catch in a particular product which is having a different design. And any product, if you see, if you are you yourself, you can look into your mobile, or you can look into your watch, or you can look into a chapel, or anything. And in that one, you see, if generally human mind is there, there is, we are all seeking for a variety, right? So that variety, how it come, that is a creativity of somebody else. It is having maybe some difference in their shape or configuration, not in aspect. So whenever actually there is a shape of configuration difference is there, please think about design, that is industrial design protection, right? So to promote aesthetically attractive products for encouraging creativity, consumers and the public at large are getting benefited. So consumers are, so of course, actually, if you are as a consumer angle, so if your country, if your company is manufacturing a different variety article, a different product shape or configuration, of course, you will get a more selling, and at the same time, as a consumers, we will get more benefited because we are getting a different variety article, right? So 10 years ago, actually, what is there? They are competing on price. Today it is quality, and tomorrow is design. So this was the motto. And who can get the design protection? It anyone, whoever invents new original and ornamental design, shape or configuration for an article of manufacture. So article of manufacture is there. You can go for design protection. So you can see, because this is Kubato, sometimes you can able to see this Kubato, how it is looking. So it is. And you see, because this is a tire. So yeah, there is a flower case. So different consumer products are there. So I am actually, as far as design protection is there, I am just talking about the external appearance of the particular product only, not functional aspects. So after seeing this particular product, actually we are getting attracted to buy that particular products. Okay. And the pharmaceutical products also, this external shape and textile and jewelry. So these and all will come under design protections. Okay. So now actually we are covered patent, trademark, design, and because geographical indication. Uh, Geographic indication actually, from you can able to correlate, because MES Engineering College is at Kuttiparam, and nearby actually Tirur is actually, I think this is very near to Kuttiparam. Uh, so Palakkad also. Palakkad is
Okay.
there. Palakkad also
Vettila.
very near. Hello? Hello? Any doubt?
Tirur
Hello, sir?
Vettila, sir. Tirur Vettila. Tirur
Yes,
Vettila has.
Tirur Vettila only I am telling. Tirur Vettila. Yes, Tirur beetle leaves. Beetle. So Tirur Vettila, actually, because that is stories there earlier before independence. I attended the Tirur Vettila for that agriculture meet also. What their agriculture people were telling, actually, Tirur Vettila, if you take, means actually our leaves will become easily red, I think. So there is a different variety of Tirur Vettila, and earlier, before independence, they used to export that particular Tirur Vettila to Sri Lanka and other countries, it seems. Now, because they were telling about that much, they don't have that demand for that, maybe different story. So, but that actually, how that Tirur Vettila has come, Tirur Vettila, actually that Vettila, this one is coming because of the climatic conditions of that particular area, soil conditions of the particular area. Maybe some this one is developed by this one. So these type of people's right has to be protected. So another case you can see, because Palakkad and Matta, or Palakkad and Nyavara, or even in Wayanad Gandakashala rice, or so similarly, so many things you can see, because Aramula Kannadi, Aramula this one, so Balramura
Nilam,
Kaitari.
Nilambur
Uh,
Tek.
so
Nilambur Tek.
yes, Nilambur Tek. Yes, Nilambur Tek. Actually, that the process is under good. So many things are there. Actually, earlier this one was individual right, but of course, I am telling, for GI, that is a collective right only. Not individual can apply for GI. Please note this, because if they want to get a GA right, actually they have to form an association or committee, and with that, so because user individually they are having right, but GA is granted for an association or board or anything. So similarly, if you can see, actually Aramula Kannadi, they are having, because some around 50 or 20 families are there, they only knows how to make it, and their right has to be protected. So in that case, they have to go for GI. And Trishur also, there is a particular rights or IGs, I will come. So Geographical indication is notice to consumer that product comes from a particular geographical area. So GA protects commercial interest of the people in that region where product originates. So all the producers in that particular region can use GA tagging, even they have different trademarks, of course. So what is their customers must not misled, marking must not be misled, non-dilution, economic prosperity. You can see, because I will tell this is Darjeeling tea. This is the first GI registered by this GA office. You know Darjeeling tea that because Kanjipuram sari, no need. Actually, everyone knows. Actually, Kanjipuram sari. People actually this 60 kilometers far from Chennai. Sometimes you can see actually people from Kerala used to come for Chennai, and they will take some car to purchase something. So what is the relevance? Because that is actually some families, some around maybe some 50 or 100 families will be there. They are manufacturing this one. So that is the GI. And you can see, because Trishur, you know, this rice is their Pokali rice, and their cultivation is different. Yes, full water, and in between their rice they used to cultivate. So this is Pokali, this is GA registered. And you sometimes you may be aware that, because you know there is a place called Vazhakulam. If you go into Perumbavoor, that place actually this actually pineapple actually that is grown at Vazhakulam only. Vazhakulam pineapple you may be knowing. So after getting initially they were telling because some of the agricultures I had asked, they were initially they were having 30 rupees. After the GI they got some 90 rupees or this one. So that is there, because after getting a GI actually it will become famous. You know Marayur Sarkara. So maybe people, I don't know how long actually they had applied for Guruvayur Pappadam or not. I am not sure about that. So these are the things which is there. So Salem fabric, so Solapur Chadar and Terry towel, and because Mysore Agarbatti, Chanabattanam toys, and the Coimbatore wet grinder. So this wet grinder, you may be thinking why this one, because that particular stone is special like that they were telling. So that depends. Mysore traditional paintings, and now actually GA also we covered. Now we can go for the copyright. So this is a different form of copyright. You may be, because you know this is literary work. You will write novels or story, and we know the films and sometimes dramatic works and music, artistic and sound recording. So moment this is, if you are creating any of the literary films or dramatic, musical, artist, sound recording, so you have to think about copyright. So copyright is the appropriate office for protecting this. So a copyright is a protection offered to the authors of literally dramatic, artistic, musical works, producers of cinematographic films and sound recording. So the work is actually it has to be expressed, and it has to be a material there. So you may be thinking that it is having a bundle of rights, including right of reproduction. So as a example, one person actually you have written some story in Malayalam, and if somebody want to copy into Tamil or Hindi or English, actually your consent is required. Otherwise, they cannot able to copy. And you may be thinking remaking of Malayalam film to different languages. They are taking permission from the producers. And similarly, communication right, you know, and adaptation. Adaptation is and translation of the work. Adaptation means, and if you are writing a particular novel or story, if somebody want to convert it to a drama or a film or serial, they need to take a permission from you. So this is a bundle of right, and you see actually economic rights are reproduce or making copies, issue copies or sell or distribute or display to public, adapt, license or licensing, and nobody can able to mutilate without this one. So this is a moral is also there.
Sir,
And
is there any time frame like 10 years for patent? Then how many years in copyright, sir?
yes, I will come to that. Actually, copyright is actually very wrong. Our total lifetime plus 60 years. So copyright frame is more actually. So author is the person who creates the work, and the musical work is composer and photographer and computer this one, And you know, the copyright actually it is having a bundle of right. Actually, total our lifetime plus 60 years is there. That is a term. And actually, this one moment the copyright is there. That is automatically protected worldwide. Copyright, no territories are available for copyright protection. This is one of this one. So because there is no language barrier. If you see, you can, because once it is protected means it is worldwide protected actually. There are many right holders in the music because lyrics who write this one, so composer who said the music, singer who sang the song, musicians who perform the music, person who company produced the right sound recording. And because infringement, you know, somebody is copying, and actually both, you know, because even a sub-inspector can raid a particular this one and they can seize the products. You might have seen in the newspaper also sometimes, because that is happening in Kerala also, and in Tamil Nadu, other regions also, and unauthorized downloading of the programs, unauthorized downloading of the films, copying of the, because these are happening actually. So that and all actually it will be protected under copyright. Like unlawful downloading and sharing of the copyright music of the internet, bootlegging recording. So sometimes remedy is there actually, accordingly, based on if you are going to the court of law, because this is the problem. So generally, they used to tell actually copyright actually no need to register. But whenever actually there is a copying matter in the before the court of law, if you produce the copyright certificate, means actually you will get a favorable judgment. This is one thing actually. Punishments you see, because and any person knowingly infringes abets this copyright act commits criminal offense under section 3. So minimum maybe 6 months this one, later on it can be changed. So depends upon situation, it will be enlarged also. This is a criminal, both civil remedy and both criminal remedies available for copyright. And one sir was telling, again I am returning, the term of the protection is our lifetime plus 60 years. So and copyright subsists worldwide because of the Berne Convention. If you produce something in copyrighted material, that is protected worldwide. And there is even though actually I am telling no necessity of registration, but one actually registration is required means, suppose actually somebody is copying your right and then you came to know, and if you are taking any infringement action means before the court of law, actually if you are copyrighted, you can able to produce the certificate, then you can able to get the favorable judgment. So that case actually better to take a copyright registration and get a certificate from the government of India. And because what is the criteria? Criteria is it should be original. It should be originate from an author, product of independent creation. Fixation should be expressed in the material form. So you may be thinking, so what is this one? So is same photograph. You can see different people are taking in a different angle. So each photographer is actually is an original photographer only. And if once it is fixed in the photograph form, that his rights are protected. So that is originality should be there. And because in again I will come for this startups and for the MSME also. So there is actually for the patent there is a we had made a expedite examination. So if the startups they want a patent office to grant immediately, there is a provision is there, they can file a one expedite request for application also. Then it will be processed faster within 7 months or within 1 year it can be granted. And actually there is a scheme for a startup. There is a called SIPP scheme is there, that is available, and actually you can able to check in our website. So actually for the in that one you can take a patent attorney. Actually that patent attorney fees will be paid by the government department itself, and you need to pay only government fees. Okay, that is there. That is a scheme is called SIPP scheme, and the expeditious fee. So for the startup and the you can use that opportunity. And if not only startup, and suppose actually your inventions is from if any inventor, any applicant, if one of the applicant is a woman, you can use this expedited application. Or otherwise, any government department, personally, any government department or government institute, they can also file for expedited examination. And now actually for expedited examination, separate queue is there. I told you now, within 7 months or within 1 year, it will be granted. And examinations also now mainly patent application, you have to see actually all examination reports will be sending by the mail only. So mandatorily you have to give your email ID and your mobile number, so that this office can able to contact you. So and with the FER response within 6+3. So at the last, actually, this office also, because now earlier, of course, as Madam was telling, there is a backlog. Now, actually, this office is doing at the level best to clear the backlog. So at the earliest, actually, we are applicants are getting the patent. So now even actually this office is giving hearings through VC only. So VC hearing. So no, actually applicant is no need to come to the patent office for physical attendance is not a must. So wherever you are, actually the link will be sent to your email. So there actually similarly you are attending the this presentation and similarly you can attend the hearing whichever place you suitable. So so actually for the government side and for the department side, maximum favorable for the applicant it is doing. So some financial assistance you can see, because the technology development board is there. Now this National Research Development Corporation is there. There is venture capital is there. So otherwise informations are available in this particular websites. So they are also doing a lot of inputs, a lot of informations. They are giving lot of even in National Innovation Foundation is there. They are actually some of the grassroots level, they are themselves filing the patent application. They are granted and they are giving for the inventors and grassroots level inventors. So last, actually, you can able to see. So you may be thinking, what is the career opportunities in IPR? So career opportunity, you can become an IPR manager, you can become a technology transfer expert, or you can become a patent examiner, trademark examiner, or you can become a patent and trademark agents and attorneys, because because like advocates are arguing on behalf of the applicants in the high court, different level of courts. Similarly, you can, one patent agent is there, means actually he will draft the applications for you and he will sign and he will argue before the patent office on behalf of your behalf. And some of your friends, actually they want to become a patent agent, means they have to clear one exam conducted by the patent office. Every year they will conduct one exam. Once that exam is cleared, means actually they can act as a patent agent. You can see actually then I think actually my proposal is there, every college sooner or later, actually every college, every technical institutes, actually they should have a patent agent or IPR manager, because that is a must. And patent search expert. So because generally we used to search novelty, inventive step and all. So people want to know whether that is novel. Then only they have to they need to file for a patent application. For that one, they have to carry out the search. So search experts also mandatory. So one thing is there, I think MES Institute already they are having one IPR cell. So along with the TBA, if they are forming, means please start one IPR cell, actually intellectual property rights cell, at least patent cell, so that actually lot of informations there you may be coming. So that technology from the students also, from the faculty members also, you should not go waste. It can be apply and it can be converted to the patent, means actually it will be additional generation for the college itself, and additionally that technology can be used for the small scale industries or somewhere startup companies or there nearby or other, because now actually, because because now is a global village, and there is no technological barrier for us to take this one, even because somebody has invested some engine in say Todupuzha. So actually that particular person, actually that particular engine is necessary for UK. So that UK company could able to identify this person from Todobuja, and they are sending the tickets, everything, and asking him to come for a presentation to UK for that one. So that depends on how and who is the search. We also don't know at the time. So this is the thing. So my request is we can innovate and create and obtain a patent right and enforce your patent rights. And now without patent protection, you can see there is no growth. Actually, growth is stagnant, and with the patent protection, uh, the growth is actually is exponential. So this is the condition. So with this, actually, let me conclude. And if you have any questions, I am glad to answer your queries. So please, any questions means you may please ask me.
I hereby request the participants to intervene to clear your doubts.
Ajith sir, hello. Ajith sir.
Yes, yes, sir.
Hello, Ajith sir.
Yes.
Sir, I have heard that I have heard from one session that we can publish the Gandhi's autobiography now because it has crossed 60 years, so we can even publish that thing. Sir, can we do?
You can publish. Actually, it will not come under copyright because Gandhi's lifetime plus 60 years over. Right. This is a beautiful question. Thank you for that.
Yes,
Because
yes.
that is because the 60 years over. So that actually, because of course, I know that you will not publish the same thing, but actually that
Sir,
copyright boundary is over.
not intended. I would like to ask. I have
Yes,
heard
yes,
that.
yes.
I would like to verify that, sir, that my faculty has shared that. So I would like to verify that thing, that fact, whether it is
Yes,
right
yes,
or
yes,
wrong.
yes. You are absolutely right. I'm making it because one way if we are talking, that's one only actually it will be going to there because you are. I know that actually I am taking class for the faculty members and I used to tell actually one faculty member is equal to some around 3,000 students. So if you could able to understand this particularly because you will share of course this knowledge to some around at least some 3,000 students because they will be getting benefited. So even so 30 faculty means is equal to I am taking around some around say example or 9,000 or students. So that is wonderful, sir. Thank you. So I am taking that view only.
Yes, sir. Yes, yes.
Hello.
Hello, sir. It is clear, sir. It is clear. It's clear.
Yes, yes,
Hello, sir.
yes.
Sir, if you want to sell a patent, what is the procedure, sir, for that? Do we have to approach any attorney or how we can do it?
And actually, because you see, now first of all, actually, because attorney generally advocates because if people will not cheat, and that is the reason actually they are approaching a attorney or advocate because there should be a lot of negotiation. Something is there. So once actually you see it is equivalent to the selling our property only. Because that is a property. So because how you are selling your property. So before physical property, I'm telling house or land or something, it is similarly only because civil remedy only available. So yeah, so if you want to sell, actually you can talk directly also. So because first of all you should understand what is the commercial because these are all business tool, right? I am telling. So what is the uh, commercial? This one is there. Say example, actually, I will tell one example. If we coconut climber, because that is there, and coconut climber, sometimes it may be recorded in India, it may be recorded in Sri Lanka, sometimes in Pakistan, Bangladesh, and all. So same actually, the coconut climber may not be recorded in America, right? So what is the potential? What is the boundary? You have to understand. Accordingly, negotiations can be done, and you can fix the rate. There is no. So if you are confident enough, you can able to bargain and you can able to fix the rate. That is fine. That's good. I hope this is enough. I think.
Okay, thank you, sir.
Yeah.
Sir, actually, how long it takes for the examination after publishing the patent?
Yes, earlier there was a this is okay, but there was a backlog, but nowadays actually we see depends upon this one. Actually, we are within 2.5, within 3 years, actually people are getting normal patent application, normal request. And if we are asking for expedite examination, so within 7 months to 1 year expedite examination, because not all applicants can able to go for expedite examination. So once the applicant is going for expedite examination within 7 months to 1 year, actually patent office is granting the patent. If everything is okay. If everything is okay, because objections, everything is over means, everything covered means, actually within, even I had granted within 7 months to some of the people patent.
Okay, sir.
That depends.
Thank
Yes.
Ajith sir, one more question. Sir,
Yes.
is there any assistance or program to support grassroots level farmers or something like that? Like those who are not educated, but they are creating so many inventions, or they are trying to find out simple machines and all. Sir already mentioned coconut climber and so arecanut cutter and so on. So, is there
Yes.
any what I call support given from your side or government of India?
Yes, actually, because the actually patent office, of course. First of all, I will tell actually patent office, presently patent office is supporting for the startup companies. Startup companies only. For the startup company, if they want to file an application, patent agent, that professional fees will be paid by the department, and the remaining office government fees only they need to pay. So for the startup companies, department is giving a scheme called SAPP scheme. You can able to search in Google. So you can entrust any attorney, and they will proceed application for you, and that their professional fees will be paid by the department. So for startup only, our department is doing. But as sir was rightly asking, there are organizations are there. They will support grassroots level inventors. Because if you see, actually, lot of inventors from Kerala itself, they got patent through these people only. Now you can see National Innovation Foundation based on Ahmedabad. Their website is www.nifindia.org. Otherwise, innovates www.indiainnovates.com, or otherwise www.60.org. Hello. So these type of organizations, they used to help the grassroots level inventors, and for up to patent, and sometimes they are helping for the commercialization also. Sir.
Okay, sir. Thank
Hello.
you. Okay, sir. Clear.
Yes. Okay. Any more questions? You can ask in Malayalam also. Actually, no, but because I know Malayalam, I am basically from Alleppey. So if you want me to talk in Malayalam also, I can able to talk. So no, if there are questions, I can able to answer in Malayalam also, no problem in it.
Sir, kindly share your contact details, sir, in chat box.
Yes.
Yes, we will.
You can ajithyam75@gmail.com. That is my email ID.
Yes, sir. We will share the details in the group for your benefit. Yes,
Okay,
we'll certainly
fine. So if you have any doubt, you please mail me, because why I am telling, sometimes phone is there, sometimes some meeting, because I cannot able to answer properly, then that people will be angry on me. So that difficulty also there, because right to this one. But if you are sending a mail, means whenever I am free, I could able to give answer properly. That is what.
Okay, sir.
Otherwise, any this one evening office hours, sometimes some hearing and all, then actually sometimes I may not be in a position to answer properly. So that problem is there. But mail means anyway, whenever I am free, I can able to answer. Now if you have any questions, means you please ask, because I know also later on, because sometimes it is happening like that also. Later on you will think, and later on some people are asking doubts by mail, and sometimes they are, whenever I am free by phone also, they are asking, so I could able to give the answer. Any more questions?
Sir, how international patent is you can obtain? International patent.
Yes. Yes, that is a good question. Actually, sir, you find, first of all, international patent is not there. So, because sometimes papers, they used to tell that there is a global patent, there is an international patent, like that is there. But it is not there, because patent is territorial right. First of all, that. But there is an international filing procedure is there. So if you file one patent application within India, that is called a not normal application, that is called PCT application, Patent Cooperation Treaty. Actually, it is governed by WIPO, World Intellectual Property Organization, based on Geneva. So if you file one patent application, it is valid around 159 countries. So once if you are filing an application within 30 or 31 months, you can enter into each national phase. So there is no international patent. That is a filing procedure only. That is PCT, international filing procedure. PCT means Patent Cooperation Treaty. Sir, is clear?
Okay. Sir, the brand like Mercedes M and Toyota T like this, whether they are internationally patented or what is this protection?
Yes. Actually, this one, actually Mercedes, Benz and all, actually that is not a patent right. That is a trademark right. Trademark, because the moment if you see Mercedes or Benz, everything, that is called a trademark, not patent. So the name, the moment if you see that one, that can be put under trademark only. So once actually if you know that actually that is not a patent, if India also you cannot get a trademark for Benz or Mercedes. Why? Because that is well-known trademark. India government has made some list. These are all internationally reputed trademarks, so that cannot be get a trademark. So because actually sometimes some around underclothes or something they took a trademark for Benz or something like that. So that is under revoked, because that so that cannot be trademark, sir. This is so your question is not for patent, that is for trademark, right? Clear?
Okay, thanks.
Sir, I have a question, sir.
Yeah, please.
Sir, actually, my wife graduated from VIT Vellore, and she have 7 patent in her name, but not alone for her name, because it was collab work. So the patent is under her name and university. It is being renewed by university every year.
Okay.
So my question is whether my wife has any benefit in that, or just for a namesake, the patent is.
Actually, this one, who is the patentee? Who is the patentee? That one you have to check, sir.
Okay, patent is
because
VIT University.
VIT University. So they are the right holders. Actually, your wife may be inventor for that one.
Yes.
So inventor actually definitely he is assigned. She might have, your wife might have assigned the rights to VIT in the for application form itself. So now VIT is the right holder.
Yeah, they are
VIT
renewing
is the
every
right
year.
holder.
Yeah, they are renewing.
Yes. Every year. So they are the right holders. Actually, this one, very good question. Sir, actually, you please hear, because this is very much important for all faculty members. So this is a problem for all faculty members. Actually, one inventor is there. They are assigning their rights to the company or college. So college is the applicant. So once application is granted means, of course, that college and the university will be the right holders. But generally, I have talked with so many researchers and so many faculty members. What they want their name to be printed in patent certificate. And there is a provision in there in the Patent Act. If you are filing Form 8 along with the application form, so inventor's name will be printed in patent certificate, and along with the, because generally actually faculty members, researchers, they don't want the fund or they don't want the this one. But of course, actually, since they are creators for this one, their name has to be printed in patent certificate. So in that case, in Indian Patent Act, there is a provision is there. You can file, of course, Form 8. Once Form 8 is filed, means they can file, their name will be printed in patent certificate. But this case actually already patent granted by 7 this one. Now actually Form 8 cannot be filed. If during the process before grant, if you are filing Form 8, if with the permission of the applicant, then actually their name will be printed in the patent certificate.
Yeah, okay, sir.
Sir, it's clear?
Yeah, absolutely, sir. Clear.
Yeah.
Sir, such cases, the teacher cannot be credited, isn't it? Can
Uh,
use that credit in her CV?
Yes, actually, because one thing is that nowadays, actually, because there is a, because this is actually very tricky issue, because actually once in REC Calicut also this issue has high, because as a patent office, we don't have any problem. But you generally what college authorities are telling, because the faculty members and researchers using their own money, their own fund, their own resources, and inventing something, so they are the right holders, because that is depends upon the college, because something is there, I think. Now you are so of course actually the faculty members may be having credit, because once it is published, their name will be published as a inventor. So of course actually application, actually it is generated from an inventor only. But the right holder, I am telling, once it is application is filed, generally actually college will be the applicant if college is applicant. Sometimes actually independently faculty members also independently they are filing. So that depends upon how the college dealt with, because you have to check with their college management also. Because I cannot able to, some college management is allowing independent filing, some college management is not allowing. So that depends upon the situation of your college, which I don't know, because some students independently filing, some students actually assigning their rights to the college. So this depends upon the situation to situation, because money who is contributing, because after all everything is money involved, right, sir? Actually, patent office is not a safe for that one, because this is like a registration granting authority. So whatever we are filing, whose name it is coming, we will grant it. But in general way, because REC also NIC, I was giving a lecture, so that professor was very angry on me, because there is a contract is there, it seems, in the college itself. So researchers and faculty members, if they are creating some innovations or some intellectual property rights, actually college is a right holder, some contract is there already there, it seems. So that depends upon the contract which you have, that you have to answer. Sir, actually nothing patent office is not right to say about that. I think it is clear now. Hello?
Yes, sir. Yes.
Yes, sir.
Any more question?
Is there any other queries from participants? If so, please ask, or otherwise we will proceed and this session. Hello? Is there any
Hello?
queries more?
There any questions, further questions? No.
Okay. Then actually, then I will thank you. Actually, it is a wonderful session, because a lot of interaction has happened. I think you are all very curious to know. So whatever which with my limited this one, I could able to contribute. And thank you for your patient listening. And so hope actually we can able to meet in different forum at any level at the any time. So thank you, one and all, and happy inventing, happy patent. So I request, because I am a part of patent office, of course. So I hope actually a lot of patent applications will be generated from your end in shortly, because that is what the country demands, and that is the policy which is adopted by National Intellectual Property Policy, which is adopted by the Government of India. Thank you, one and all. Thank you.
From 20 plus years of experience, versatile experience in the specific field, you have given relevant insights and guidelines which help us to serve the young aspirants and inventors better, sir. You have explained all the things in all practical guidelines with the clinching examples from our daily life. We are extremely happy to have you. We are so fortunate to hear from you. On behalf of the entire Mechanical Engineering Department fraternity of MES College of Engineering, I hereby express our sincere gratitude from bottom of our heart. Thank you, sir. Thank you very much for your presence and blessing this event with your esteemed discussion.
Thank you. Thank you.
Thank you, sir. Thank you very much.